Welcome to Ballantyne Law, clear, practical legal advice that works.
Hello, I'm James Ballantyne and I'm the Managing Director of Ballantyne Law, and with me today is Alyssa Holloway, who's a Senior Solicitor and is in our commercial and property teams. We're going to talk about something that I think is of pretty critical importance to any small business that has more than one owner, and what is that?
Shareholders agreements.
Okay, and what is a shareholders agreement?
It's essentially a rule book for the way that the different shareholders and directors of the company interact with each other and make decisions.
If you were to summarise really quickly why a shareholders agreement's important, how would you do that?
I'd say that it is critical because it can prevent a lot of different disputes. It means that if a dispute arises, because no one goes into business expecting one to arise, but if a dispute arises, you have a process to follow for resolving that dispute, or just a term or a clause that resolves that dispute before it even starts.
Our litigation team, it'd be fair to say that they see a lot of shareholder disputes where there's no pathway or no mechanism for how they're dealt with, and that ultimately tends to lead to an increased spend on legal advice, legal work, and even going to court when a dispute can't be resolved.
Yes.
So companies typically have, a lot of people are aware, have a constitution or replaceable rules. What's the difference between a shareholders agreement and one of those documents?
Well, a company constitution is about corporate governance and its guidelines, but the shareholders agreement is a contract between the parties that make up that company.
A lot of small businesses, and particularly startups, seek external investment and new shareholders and otherwise. Is there anything a shareholders agreement does to help in that regard?
First and foremost, is a process within the shareholders agreement, most likely there can be for the introduction of new shareholders and a process to be followed. But also it's favourably looked upon by any incoming shareholder to see that there's good corporate governance and systems already in place.
For businesses that might not be looking at capital raising or seeking further investment, so what I would sort of talk about your typical family business or a company that's owned by friends or colleagues, are there still benefits to having shareholders agreements?
Yeah, definitely. I think the tendency is to lean towards, we're friends, we're family, we're not going to have a dispute, but it's important for everyone to be on the same page and for the expectations to be clearly outlined, and a shareholders agreement can be tailored for that.
So it's probably fair to say that a handshake deal, when the rubber meets the road, people often have different recollections about what was agreed and what wasn't, and who was going to do what.
Yeah.
And so having a shareholders agreement really...
Well, it records the reality of the expectations between the parties and their obligations, rather than just relying on everyone's recollection of what they agreed to.
Okay. So where do disputes typically arise in these sorts of businesses?
Two main scenarios, which is where the business is not doing well and you need to figure out an exit strategy and who is left holding the bag, so to speak. And then where the business is doing well and it's making money, there might be a dispute over profits. One party might think that they're contributing more than the other, or it wasn't agreed to, and they should have a greater share of that.
Okay. So what typical areas would you see addressed by a good shareholders agreement?
As a minimum, we would see provisions relating to management, so who in the company can make decisions about certain things, who has the right to make those decisions, who has the right to question or challenge those decisions. Control, so who has voting power, how much voting power, how can that voting power be drawn upon.
What sort of decisions require what percentage of a
vote? Exactly. So what decision could be made sort of on the fly, so to speak, and what does call for a voting of the shareholders. Provisions relating to disputes, so the steps to be taken by the parties before things escalate to legal proceedings. To exit provisions, so what happens when a shareholder wants out. Who can buy those shares, the approval process for any incoming shareholder.
And even in that scenario, you'd expect things like restraints. So after someone departs, they can't necessarily go and set up a competing business. And why are exits such a big issue for small to medium enterprises?
Oftentimes the shareholders are working in the business, so it's also the leaving of an employee as well. There's a lot of corporate knowledge that comes with that, processes. You want them to be obligated to provide a sufficient handover and training of their replacement.
It'd be fair to say that shareholders agreement would also go hand in hand with succession planning for a business about what's our strategy here. Are we looking to sell this business one day? Are we passing it on to family members? What happens when those key people want to retire? Those things can be addressed. Sometimes with some of the agreements we talk about buy-sell arrangements or insurance funded buy-sell arrangements. Can you tell me a little bit about that?
So typically we address two types of exits. Voluntary exits, that don't want anything to do with the business anymore, moving on to different ventures. And then there's involuntary ventures. Say someone gets in an accident where they're incapacitated or they sadly pass away. You then look, if there's no shareholders agreement in place, the spouse, the kids of the person who has passed away may sort of have to come into the business or may be entitled to it.
And that's not necessarily something the other shareholders want or have agreed to.
Yeah, I would say not in most cases, unless this is a family business.
But there's got to be a mechanism for getting value for that departing shareholder for their interest.
Yeah, and in which case then we can look at provisions for there to be a buy-sell requirement where the remaining shareholder can buy at a cost funded by insurance that's in place from the estate of the deceased shareholder, their interest.
Yes, and provided, of course, insurance cover is commercially possible, you would have insurance policies on life and TPD and so on, and that would then fund the buyout. So the family and the legal...
The family isn't out of pocket.
They get their value for the shares. The ongoing shareholders can continue with the business with the control that they need. In a lot of cases, it's not just a 50-50 shareholder. There might be numerous shareholders and some may have more control than others. There are protections in place for those minority shareholders in shareholders agreement.
Yeah, definitely. And this is where the customisation comes in of the shareholders agreement. If you have minority shareholders, you could include the rights for them to veto major decisions. They might not have any sort of large shareholding to be able to do that ordinarily, but if a decision is large enough and that can be defined under the agreement, then they have the right to veto that.
So, for example, if there were a decision to issue new shares which would have the effect of diluting the existing shareholders, that might not be possible without all of the existing shareholders or amending the shareholders agreement or those sorts of things. You put in place key decisions that require a specific percent, which could include 100% of shareholders to agree to it, while the more mundane day-to-day decisions might rest with the control. When would you look at doing a shareholders agreement?
Ideally, you would do it at the beginning, but ultimately that's not always the case. The best time is now, as soon as there becomes a need for it, as soon as there's a business with multiple shareholders.
And if not now?
If not now, as soon as possible.
Because
there's merit in putting it in place, even while now everyone may be on the same terms agreement is in place at a high level perspective and there's nothing on paper. It does nothing to say that next week there's not a dispute that arises.
Do you think it's overkill for small businesses to have a shareholders agreement?
Not when you think about the cost that could happen. You never think it's going to happen to you when you think about the cost that litigation brings.
The shareholders agreement are likely to save
It's a fraction.
It's a form of insurance realistically, isn't it? No one goes into business expecting there to be a dispute, but the courts are littered with disputes of former friends or family members who have reached a disagreement.
So most especially sometimes.
And what about some businesses aren't necessarily owned by a company? They might be held through some other kind of structure like a partnership or a unit trust or any number of those. Would a shareholders agreement work in those scenarios?
Not in those instances, but there are similar agreements to apply to those circumstances, such as a partnership agreement or a unit holder agreement. But basically where there's multiple parties involved, there needs to be an agreement with how they are governed amongst themselves.
What's the main takeaway for this discussion then?
Well, the takeaway is that if you don't have the proper corporate governance, which a shareholders agreement is a big part of it, you're open to the disagreements amongst yourselves. I think sometimes we focus too much on the issues that can arise with employees and leases, and there's a lot of issues that can impact small businesses, and those are important matters to address. But no one ever expects it to be issues coming from the inside that ultimately be what brings an end to an otherwise successful venture.
And having an agreement in place doesn't mean you don't trust your partner.
And I would say if your business partner is steadfastly against it, it's probably a red flag.
And if someone were interested in talking about shareholders agreement, how might they do that?
They should give us a call and speak with our lovely team about booking an appointment to discuss what their shareholder agreement might look like, and we can help them with that.
For more legal insights, subscribe or visit ballantyneLaw.com. We're here to help.